6 of tort law. Today I'm going to touch on trespass versus trespass on the case, and the torts of malicious prosecution, abusive process, and intentional infliction of emotional distress. So, trespass v. versus trespass and case. These were old writs of related to trespass, and we kind of already covered the history of them. Trespass was related to intentional infliction of violence, and gradually people came to recognize injuries that did not have to deal with violence, and but they had to continue using the writ of trespass, and the Court of Chancery, I believe, would just ignore the fact that there wasn't violence. Though in order to get the writ heard, they would have to claim violence. So eventually they developed trespass and case, which dealt with more indirect injuries. So as opposed to throwing a log at someone, maybe you negligently left the log on the road and someone ran over it with their horse and buggy, for example. So trespass in the case was created to deal with more indirect injuries, and because of their indirectness, they had a more burdensome burden of proof. So historically, damage was required for trespass, but not trespass on the case. However, fault was required for trespass and case, and not for trespass. I think that first one that may have been the case historically, but now it's damage and fault that are required in torts derived from trespass in the case, whereas just intent is required for torts derived from trespass. So as we've seen with battery and assault and false imprisonment, all you have to do is intend to interfere with the person, and whether there was damage or not is the plaintiff doesn't have to prove that, and whether you were whether you were at fault, the plaintiff doesn't have to prove that either. They just have to prove that you interfered with them. And then it's up to you to say whether or not it was your intent to do that, or whether or not it was through your volition that you did that. Basically, whether you were at fault. So, writs of trespass on the case deal with indirect injury and have more difficult burdens of proof. Examples are malicious prosecution, abusive process, and intentional infliction of emotional distress, which we're going to go through today. So, malicious prosecution. The reason that we have malicious prosecution as a tort is to protect individuals from baseless accusations, and to protect the charter rights of people who are unjustly prosecuted by the Attorney General. It's also historically to protect individuals who brought prosecutions, because it was the individual's responsibilities to bring prosecutions. And I guess the difficulty element, the difficulty of proving this tort was to protect individuals who brought prosecutions. And also the difficulty is to protect prosecutors, who are often the ones bringing prosecutions. So it mostly deals with criminal law, though sometimes it does touch on civil cases as well. So what is it? It's if someone is wrongfully prosecuted through a lawful process. And what does the plaintiff have to prove? They need to prove that the defendant, the person they're bringing the action against, initiated the proceeding, and that the proceedings terminated in favor of the plaintiff. So if they were found guilty, then certainly the proceeding wasn't malicious. Though that's debatable, considering the issue of wrongfully convicted people. The harder things to prove is that the defendant had no reasonable or probable cause to bring the action, or to initiate the proceedings rather, and that the defendant acted in a malicious manner. So, and then lastly, the fifth element is that there was actual damage. So we see here the difference between the intentional torts and these intentional torts derived from the writ of trespassing case, where you have to prove actual damage and you have to prove the I suppose the motive. So it's difficult. So we turn to the cases to kind of figure this out a little bit more. Well, I guess before turning there, it's the fact that you have to prove that they did it in a malicious manner means that they were acting, the Attorney General is acting deliberately outside the scope of their office. Now, early in the 2000s, it was suggested that the intent to act maliciously could be imputed from having a lack of probable cause, but that's debatable in the most recent case. Miazgo and Covello Estate says that they must deliberately step outside of their role. So, Nels versus Ontario in 1989, so we're going to be mostly dealing with the Attorney General here. This ended immunity for the Attorney General. They were protected from malicious prosecution because they were prosecuting so many people, and the courts wanted to defer to them, and they wanted to protect them from dealing with lots of malicious prosecution and accusations from people who just didn't like the fact that they were being prosecuted. However, it is it's unjust, it's against the Constitution, or it's against the Charter to restrict people's rights so broadly against any accusation of malicious prosecution against the Attorney General. So Nels versus Ontario ended that, and they said malicious prosecution will only be made out where there's proof that the prosecutor's conduct was fueled by an improper purpose or motive, a motive which involves an abuse or perversion of the system of criminal justice for ends it was not designed to serve. So, and that has been the case. In 2009, in Miazgo and Covello, they reiterated that, though they did sort of clarify the test for determining whether I guess test number 2, I believe it is, whether it's reasonable or not. Test number 3, if they had reasonable or probable cause. And what Miazgo said is that only the objective test should apply for Crown prosecutors. So it doesn't matter whether the Crown prosecutor had a subjective belief that there was a reasonable probability of success in the prosecution. It's whether a reasonable Crown prosecutor would think that there was a reasonable chance of success in the prosecution. So, and with regards to their malicious intent, again, they have to deliberately step out of their role. And you prove this by assessing the totality of the circumstances, including the prosecutor's state of mind. So you can use the subjective test to determine whether it was malicious, but not to determine whether the actions were reasonable. So, Walker versus Ontario, 1997, reiterates that the threshold for finding that the Attorney General and the Crown Prosecutor find them, I guess, guilty of malicious prosecution the threshold test must be high. And the court in this case said that Walker had proved that they had perpetrated a fraud on the process of criminal justice, and in doing so had perverted or abused their office. In Hawley versus Baku, we see that the Attorney General is insulated from actions brought for negligence, and they were also unable to impute malicious intent here. So malicious prosecution, as stated in Prue versus Quebec, does not include recklessness, gross negligence, or poor judgment. Now, the thing that does change in Prue versus Quebec in 2001 is that they did have a dual test. They had the objective and the subjective test for determining whether there was reasonable probable cause. And they were also able to impute malice from the lack of reasonable and probable cause. However, that was not the only determining factor in whether or not the prosecution was malicious. They also hired a former police officer who was being sued by the person accused for defamation. And I guess these actions combined for an abuse of prosecutorial power and a perpetration of fraud on the process of criminal justice, and thus malice. In Pearson versus Mien in 2006, we see a case of malicious prosecution against a private citizen by a police officer. The police officer pulled him over for a speeding ticket. He got angry and allegedly attacked the police officer, and then later took the police officer, had him charged with assault, and had a friend pretend to be a witness to the assault. The officer then sued Mien and was awarded $25,000 in damages for Mien's malicious prosecution. So 2001-2005, and Ontario and Fitzpatrick and Durham Regional Police, this is where police can bring actions for malicious prosecution when they are criminally charged for things they did while they were acting in their duties. However, in both these cases, the prosecutions were considered reasonable, despite the fact that they were both acquitted. In 2001, the court stated that in the appropriate case, it is proper to infer malice from the absence of reasonable and probable cause to commence or continue a prosecution. So malice has a wider meaning than spite, ill will, or vengeance, and could include any other improper purpose. And this kind of goes along with Prue and Quebec in 2001 as well, but is counter the stricter test we see in Miasco and Covello in 2009. So the police were asked by the plaintiff, who was charged with the crime, to interview the person that identified them as the robber. And they did, but only reported to the Crown that the person still insists the plaintiff was the robber, as opposed to the facts which removed probable cause to continue the prosecution. And I believe malicious prosecution was found in this case. Griffin versus Summerside City, this is an example of a successful action for malicious prosecution brought for wrongful pursuit of charges under a professional code. In this case, it's the police rules and regulations. So malicious prosecution within a regulated profession. And the judge was satisfied that the investigation into Griffin's actions met all four requirements for malicious prosecution, and also the city was vicariously liable for the actions of their employees, and thus had to pay the compensation. In McNeil versus Brewers Retail Incorporated in 2008, the retail organization essentially lied to the police and withheld exculpatory evidence. And because they pursued the charge and lied to the police, then malicious prosecution was successful in this case. Though I didn't read exactly what their improper purpose was. Anyway, this was a trial by jury, and McNeil was awarded over $2 million for the damages. He was, of course, acquitted the charges of theft. NAV Matthews in 2003 sets out the fact that the malicious prosecution claims cannot begin until the criminal proceedings on which it is based has been completed. And Bernstein versus Stoicheva Todorova is an example of malicious prosecution in the civil process. In this case, I believe it was Bernstein had a dietary program in a number of clinics. He was a doctor, and a person came to work for him, Stoicheva, and about a year later quit and opened up their own practice. Anyway, based on that, or I guess based on the fact that Bernstein sent a colleague to go try out, Stoicheva sent a colleague to go try out Bernstein's clinic, and it was essentially the same. So for that reason, there's reasonable reason to believe that the defendant had copied the clinic's special dietary program for profit. It is worth noting here, though, that the requirement of malicious prosecution is that they had no reasonable or probable cause to initiate the proceedings. That is a difficult element to meet, and it relates to the criminal more than civil, I would say. Where you must prove something beyond a reasonable doubt. So here we need a reasonable and probable cause for bringing the action, or the absence of that, I guess. Moving on to the tort of abuse of process. So malicious prosecutions refer mostly to criminal trials, and there's a need for the same policies in a civil context. But again, it's difficult here because I guess the injury is indirect, and we do want to encourage people to bring civil action if it's reasonable. So what is it? It's employing the process of the court for an improper purpose. And the plaintiff must prove that the defendant brought the civil action, which is generally pretty easy, that the defendant did so for some purpose outside the scope of the court. So there was some other purpose for bringing the action. And also that the defendant did an overt act which would provide further evidence of their improper purpose. And this is really challenging because it would mean that they would say something like, I'll drop the lawsuit if you, I don't know, give me a company vehicle, or give me a raise, or drop out of the the race for this position in the company, or if it's company versus company, for example, we'll drop the lawsuit if you stop pursuing that mine, or if you stop negotiating with this person, or da-da-da-da-da. And finally, the plaintiff, in consequence, must have suffered some type of harm. So the plaintiff needs to prove all of that, and it can be quite difficult.